There are moments when history doesn't arrive with flashing lights or breaking news banners. It arrives quietly, through paperwork, procedural rules, and a mistake someone didn't realize they'd made until it was too late. This is one of those moments. Right now, something almost unheard of in American legal history is unfolding. A former First Lady of the United States is on a direct path toward being compelled to testify under oath. Not about policy, not about politics, but about her private life, her marriage, her living arrangements, her tax filings, and her personal connections to Jeffrey Epstein. Not in a memoir, not in a friendly interview, not through anonymous leaks, in federal court, under penalty of perjury. That former First Lady is Melania Trump. And here's what makes this moment historic. This wasn't a partisan hit. It wasn't opposition research. It wasn't media speculation. It was the unavoidable result of a legal decision made by Melania Trump herself, guided by her own attorneys. A single strategic move that stripped away the privacy shield powerful families rely on to keep their personal lives out of public view. At this very moment, a federal judge is presiding over a case that opens the door to questions no First Lady has ever been forced to answer. Where do you actually live? Where do you sleep most nights? What do your tax returns say? What state do you claim as your legal residence? And do those filings match reality? Because if they don't, the law only allows one conclusion. Someone hasn't been telling the truth, under oath. And this didn't start as a constitutional showdown. It started the way many Trump world legal battles do, with a threat. The threat that backfired. Back in October, investigative journalist Michael Wolff received one of the most aggressive legal threats imaginable, a demand letter accusing him of defamation and warning of a lawsuit seeking $1 billion in damages, not millions, $1 billion. The message was clear. Retract everything you've written about Melania Trump's connections to Jeffrey Epstein. Issue a public apology. Or face financial annihilation. The letter came from Alejandro Brito, a Florida attorney who has quietly become a familiar enforcer within Trump's legal orbit. This is the Trump legal playbook in its purest form. You don't debate facts. You don't argue evidence. You threaten overwhelming litigation costs and dare the other side to survive them. And most people don't. Journalists fold. Publishers issue walkbacks. Stories disappear. Michael Wolff didn't. He's not a blogger. He's not a Twitter pundit. He's a veteran journalist who has already endured years of legal pressure, written multiple best-selling books about the Trump White House, and lived to tell the story. So when that letter arrived, Wolff didn't panic. He went on offense. The move that changed everything. Instead of waiting to be sued, Michael Wolff did something almost unheard of in modern media law. He sued first. He filed a preemptive lawsuit in New York State court, forcing the dispute into public view. This wasn't accidental. It was calculated. In that filing, Wolff didn't soften a word. He laid out every statement Melania Trump's lawyers claimed was defamatory and dismantled them one by one. He showed that each fell into protected legal territory. Statements supported by documented reporting, clearly framed opinion protected by the First Amendment, or claims stripped of context by opposing counsel. Then he escalated. Wolff accused Melania Trump's legal team of engaging in a slap lawsuit, strategic litigation, designed not to win on the merits, but to intimidate critics into silence. And with that filing, everything changed. Because Melania Trump was now a litigant, bound by rules, deadlines, discovery, sworn testimony. The fear-based legal strategy lost its power the moment this entered a courtroom. And that's when her legal team made the move that triggered the trap. The federal court gamble. Rather than fight the case in New York State court, Melania Trump's attorneys attempted to move it to federal court. On paper, it made sense. Federal courts often feel more controlled, more predictable, and through random assignment, the case landed before a judge appointed by Donald Trump himself. From the outside, it looked like control had been restored. But federal court has one rule that cannot be bent, no matter who appointed the judge. You must prove jurisdiction, and that's where everything collapsed. The rule that changed the case. The only way this case could stay in federal court was through diversity jurisdiction. That rule is simple. If both parties are residents of the same state, federal court has no authority. Period. Michael Wolff is a New York resident, which means Melania Trump now had to prove, under legal scrutiny, that she is not. By trying to move the case, she placed her residency directly at issue. And that triggers something powerful. Jurisdictional discovery. The door that can't be closed. Once residency is disputed, the opposing party gains the right to demand evidence. Not gossip, not rumors. Documents, records, sworn testimony. Michael Wolff's attorneys can now legally ask, where do you sleep most nights? Which residence do you occupy the majority of the year? How often are you in New York versus Florida? What do your tax filings state? Under penalty of law, they can subpoena property records, utility bills, travel logs, credit card statements. Because residency isn't about what someone says publicly. It's about where life actually happens. And every answer must align. Because inconsistencies under oath aren't embarrassing. They're dangerous. The detail that may decide everything. There's one fact that makes Melania Trump's position especially fragile. Her son, Barron Trump, is enrolled at New York University. Universities don't guess residency. They require formal declarations, often tied to tuition classification, which raises a simple, unavoidable question. What residency was claimed for Barron Trump? Because you cannot be a Florida resident for federal court while representing New York residency for institutional benefits. The law doesn't allow convenience-based identities, and if Melania argues that Barron lives independently in New York, the questions deepen. Where is the primary household? Who supervises daily life? Where is the center of family activity? These aren't political questions. They're legal ones. The irony no one can ignore. Here's the part legal experts can't get past. Even if Melania Trump survives jurisdictional discovery, the defamation case itself is weak. Defamation law sets a high bar, especially for public figures. Opinion is protected. Context matters. Documented reporting is shielded. What Wolff wrote falls squarely within those protections, which leads to the obvious question: why take this risk at all? Why expose your residency, taxes, and private life to sworn scrutiny to pursue a case you're likely to lose? That's why some legal observers quietly describe this as bordering on malpractice. Someone should have stopped this. No one did. No clean exit. At this point, there is no graceful way out. Dropping federal court means admitting a miscalculation. Settlement defeats the entire purpose of Wolff's lawsuit. Limiting discovery isn't optional when jurisdiction is contested, which leaves one outcome. Discovery proceeds. Depositions are scheduled. Sworn testimony begins. And once testimony exists, it doesn't disappear. It becomes record. Why this matters. This case isn't just about Melania Trump. It exposes the weakness of intimidation-based power. That strategy only works as long as no one fights back. Michael Wolff did, and by doing so, he forced powerful people into the one arena they avoid at all costs, a courtroom governed by rules, not leverage, where facts matter, where records speak, where answers are sworn. Melania Trump didn't intend to create this moment, but she did. And now, the clock isn't ticking toward victory. It's ticking toward testimony. What makes this moment especially dangerous for Melania Trump isn't just the question she may be asked. It's the timing. This case is unfolding in an era where legal records don't stay buried in courthouse files. Depositions are digitized. Filings are analyzed line by line. Every sworn statement is instantly compared against years of public reporting, prior filings, and documented timelines. Once testimony exists, it doesn't matter whether the case ultimately settles or gets dismissed. The answers don't vanish. They live on in transcripts, motions, and exhibits. They become reference points. And once journalists and investigators have them, the scrutiny multiplies. That's the part that can't be undone. Because jurisdictional discovery doesn't just test residency. It tests credibility. It asks whether a public narrative aligns with a documented life. And when those two diverge, the consequences expand far beyond one lawsuit. If sworn testimony contradicts tax filings, the issue doesn't stay civil. If filings contradict public statements, the issue doesn't stay private. If documents contradict testimony, the issue doesn't stay contained. That's how cases grow legs. And this is why legal experts keep returning to the same conclusion. This should never have reached this point. The original threat letter was meant to end a conversation, not start one. But once intimidation failed, the legal machinery reversed direction. Now it's not a journalist under pressure. It's a former First Lady under oath. And there's another layer most people haven't fully absorbed yet. This case doesn't exist in isolation. It's unfolding in a political and legal environment where every statement, every filing, and every discrepancy is being watched with unusual intensity. That means even small inconsistencies, dates that don't align, addresses that shift, explanations that evolve, can take on outsized significance. Not because they're dramatic, but because they're documented. The law is patient. It doesn't rush. It waits for patterns, and the discovery process is designed to reveal them. At this stage, the most likely outcome isn't a dramatic courtroom showdown. It's something quieter and far more consequential. A slow accumulation of sworn answers. A record that grows thicker with each filing. A paper trail that speaks long after the cameras move on. This is the part of the story where power usually reasserts itself. But this time, it may not be able to. What happens next is no longer about headlines or speculation. It's about process, about documents being produced, questions being asked under oath, and answers that don't disappear once they're given. Whether this case ends in federal court or collapses back into state court, one thing is already clear. The era of legal intimidation working quietly in the shadows is cracking. When powerful people are forced into the same procedural rules as everyone else, control shifts, from narrative to evidence, from threats to facts. And that's why this story matters, not because of who's involved, but because of what it reveals about accountability in America. About what happens when the system actually gets used the way it was designed to be used. This case is still unfolding. Depositions are coming. Discovery is moving forward. And once sworn testimony enters the record, there is no rewind button. We'll be watching every development closely, because here at the Policy Vault, we don't chase outrage. We follow the paper trail. We don't guess. We verify. And we don't stop at the headline. We open the file. If you want to stay informed as this story develops, make sure you're subscribed. And if you found this breakdown valuable, share it, because accountability only works when people are paying attention. Thanks for watching.